A modern feature film requires hundreds of creative professionals working in parallel to build a single, unified experience. But without a highly specific legal intervention, that collaborative process would stall before it ever reaches a screen. Think about the core creative team: the director framing the shots, the scriptwriter building the dialogue, the animator designing visual effects, and the composer writing the score. Under standard copyright law, the default rule is that whoever creates an original work holds absolute ownership over it. If we applied that standard rule to a film, releasing the final cut would require the ongoing legal consent of every single person who contributed an original element. This creates what is known as the veto problem. If a single co-author decides they are unhappy with the final edit, they could legally prevent a multi-million-dollar movie from being shown to the public. No studio would finance a project if the distribution could be instantly blocked by a dozen different individuals. To protect the industry from this paralysis, the law established a set of rules designed specifically for the audiovisual sector. In Belgium, the solution is found in Book 11 of the Code of Economic Law, which introduces a mechanism called the presumption of assignment. Looking at Article 11.182, the law dictates that by default, the authors of an audiovisual work automatically transfer their exclusive rights to exploit the film, including distribution, dubbing, and subtitling, directly to the producer. This is a major departure from the American work-made-for-hire system, where the studio itself is often considered the actual author from the start. The Belgian framework recognizes the creators as the actual authors. The producer simply functions as a centralized hub, authorized by law to manage the distribution and commercial release so the work can reach an audience. However, this presumption is not a blanket rule. The law carves out specific exceptions for certain contributors. Actors and performers, for instance, have a separate parallel presumption that specifically governs the rights to their physical performances. And right in the middle of Article 11.182, the law makes an absolute exception for the composers of the film's music. Because composers are excluded from this automatic assignment, their rights must be handled through separate contracts, typically via collective management societies. This system allows the producer to bypass the veto gridlock without stripping the creators of their status as the authors of the art. Centralizing that exploitation power with the producer requires strict legal counterbalances to protect the artists. Article 11.183 establishes a financial requirement. Authors are entitled to a distinct, separate payment for every individual mode of exploitation. A theatrical release pays one way. If the film is licensed to a streaming service or broadcast on television, each of those uses requires its own specific remuneration. Along with financial protection, authors retain their moral rights, the right to be properly credited, and the right to defend the integrity of their work against unauthorized changes. These moral rights only apply to the finalized version of the film, the locked cut, officially agreed upon by the director and the producer. If the producer holds the distribution rights, what happens to the film if the production company fails? Article 11.185 provides a safety net. It states that bankruptcy or liquidation does not terminate the contracts with the authors. The work isn't lost. Instead, the law gives the director and co-authors a right of preference. They have the legal priority to buy back the exploitation rights to their own work so the film can survive. The Belgian audiovisual framework functions as a balanced ecosystem. It centralizes logistical control so the work can reach a wide audience, while protecting the financial rewards and moral status of the artists. The information provided in this video is for educational purposes regarding the Belgian Code of Economic Law and does not constitute formal legal advice.